Okay, it's recording. This urgent hearing is in the matter of case number CFI 004-2022 before Justice Sir Jeremy. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai of the judge's instructions. The claimant is represented by Watson Farley and Williams, Middle East LLP. Lead counsel is Ms. Charlotte Bijlani. The defendant is not present.
Yes, Ms. Biljani.
Thank you, sir. This is an application on behalf of Gulf Wings FZE against A&K Trading Limited. It's an urgent application without notice for a freezing order pursuant to Rule or Part 26 of the DIFC court law rules. Before you've got an affidavit sworn by Mr. Oliver John Tebbit, who is a partner with Watson Farley and Williams in our London office, and he has day-to-day conduct of the matter, along with Watson Farley Williams Middle East LLP. The affidavit sets out the basis for the freezing injunction. So the first point is the applicant's substantive claim against the respondent. The claim arises from an aircraft management services agreement dated the 14th of March 2021 between the applicant and the respondent, and the debt has arisen in connection with services performed by the applicant pursuant to that agreement in relation to an aircraft known as Embraer EMB 135BJ Legacy 600. A copy of the agreement is at pages 1 to 43 of Exhibit OT1.
Well, I haven't seen the exhibits, Ms. Biljani. I've seen the affidavit, but I haven't as yet seen any exhibits.
They should have been loaded onto the court system. Can I just ask my colleague?
Will I find them on the case management file if I go to? Let me have a look. Has this claim been given a file number and reference?
Yes, Your Honor. It's CFI 004-2022. I will email you the particulars of claim immediately.
I've got the particulars of claim and I've got the affidavit because those were sent to me separately. But I can just go to the case management file if it's there, if there's a bundle there. Sorry, what did you say it was? CFI
004-2022.
Yeah.
Ms. Bijlani, were you able to submit it to the CMS, the case management system?
I believe it was uploaded. I'm asking my colleague, Mr. Whitfield, who's on the call, to check that
It's not
straight
saying
away.
anything. Hold on, I put it in wrong. Yeah, yeah. Right. I think all that's uploaded so far is the claim form, particulars of claim, and an application notice.
Right.
That's all I can.
I think the difficulty is that it was sworn after the uploading.
Yes.
It should have been uploaded.
I understand that. The question is, I may need to look at the exhibits, I may not, but you carry on addressing me for the moment. You can take it that I've read the affidavit and the particulars of claim.
Okay, I'll just ask my colleague to email the exhibits to the registrar so that they can make their way to you. So as I mentioned, a copy of the aircraft management agreement is at pages 1 to 43 of OT1. And between April 2020 and the 30th of November 2021, 88 invoices have been issued by the applicant to the respondent for services performed under the agreement. The draft particulars of claim, which I believe you do have before you, sets out in further detail the history of the relationship between the applicant and respondent and the various agreements that have been entered into since the 7th of November 2017. And you'll see in particular from paragraph 2.1 through to 2.14 that there is a history of default in payments by the respondent.
Yeah.
The sum due to the applicant is currently $1,272,799 plus interest, and further sums will fall due within a few days because further invoices have just been issued.
Yes.
And I'm instructed to issue a Part 7 claim as soon as possible after this hearing or as you direct.
Yes.
The governing law under the agreement is English law, and the parties submitted to the jurisdiction of the DIFC courts, which is why this application is before you. The applicant believes that the respondent's main asset is the aircraft, and the applicant believes it's currently located at Maktoum International Airport in the UAE at the facilities of ExecuJet Middle East. And that, I believe, has been the current location has been confirmed by ExecuJet to the applicant.
Yes. Very little information is given to me about the defendant, A&K Trading Limited, except it's offshore, established in the Jebel Ali Free Trade Zone.
Yes.
And simply the statement in the affidavit that it's believed the only asset is the aircraft. And what does it do otherwise? Nothing at all.
I don't believe that we or the respondent has much information about A&K Trading other than a Mr. Faris Deeb, who has executed recent documents that are referred to in paragraph 16 of the affidavit. You'll see from that paragraph that it appears in December, late in December, that the respondent purported to transfer legal ownership of the aircraft to TVPX Aircraft Solutions under an owner trust structure, and that immediately the aircraft was leased back to the respondent.
Yes, well, I've read that, but that doesn't. There's a significant history, obviously, since November 2017, and the particulars of claim are a little confused because whilst there's reference there to a finance lease and so on, there's also a reference to the claimant not being a party to the finance lease. The claimant simply had the management agreement, and its affiliated company, Gulf Wings Limited, was the owner of the aircraft at that stage. Now, I appreciate that there's a later sale in March 2021, where paragraph 2.10 says, but it can't be right that the claimant sold the aircraft to the defendants. It must be Gulf Wings Limited that sold it to the defendant, mustn't it? I say there's an inconsistency in the particulars of claim as to ownership of the aircraft and sale of it. And then what I really need to know much more about is the nature of what is described as the owner trust structure and the lease back.
Yes, I appreciate
those will be in the exhibit, no doubt, but you can tell me what that really means.
Well, I have to say this was only discovered the day before yesterday, but there's a trust agreement dated the 28th of December between A&K Trading Limited and TVPX Aircraft Solutions.
Yes.
Whereby ownership of the aircraft was conveyed to TVPX Aircraft Solutions as owner trustee.
And what does that mean? That they hold the property as trustee for the defendant?
Yes, the title, well, it indicates that title to the aircraft is conveyed to the owner trustee by a bill of sale.
I understand that, but what's the trust? Who does TVPX hold it on trust for if it's called an owner trustee? Does it hold it on trust for the defendant? That would be my...
Sorry, the trustor, sorry.
I'm looking at paragraph 16 of the affidavit. Would I be wrong in reading that as saying that the defendant, which had bought the plane from the associated company of the claimant, then conveyed it on the 28th of December to TVPX Aircraft Solutions Incorporated, which holds the plane as trustee for the beneficial owner, which is still the defendant, with
Yes,
also,
I mean, in the recital,
with also a lease back to the defendant of the same aircraft.
Yes. So,
have I understood that right? I haven't got the documents, you see, so I can't tell.
I believe that must be the case, because in the trust document that I'm looking at,
Yes.
it clearly states that this agreement is designed to create a business trust in order that the owner trustee may hold the aircraft, title to the aircraft, until such time as trustor directs owner trustee to distribute it in accordance with trustor's instructions.
Right, and who is the trustor?
The trustor is defined as A&K Trading Limited.
Right. Right. Okay. Well, that's what I thought. And at the same time, there is a lease back to A&K Trading. So in reality, A&K Trading is the beneficial owner of the plane,
Yes.
as well as being a lessee.
Yes, that's right.
Okay. Right. Well, that's rather what I'd assumed. I think, as I say, you're going to need to correct some of the paragraphs in the particulars of claim, which
Yes.
talk about the earlier owner and finance lease as being originally with the claimant as opposed to the claimant's associated company. It says inconsistent things there, but that can be put right. All right. Okay. We are where we are. Thank you. Carry on.
I just wanted to mention, sir, I'm afraid I don't have any evidence. I certainly haven't seen any evidence of this, but I am instructed that the gentleman that executed these trust documents,
Yes.
Mr. Faris Deeb, is named as being CEO of A&K Trading Limited. I'm informed by the applicant that they have had previous dealings with him, and he has been subject to criminal proceedings and imprisoned in the past.
In what jurisdiction?
I will have to check that. I'm not aware of the specific facts, but that's the only real information I'm able to share with you in terms of any specifics.
Rather important in the context of a freezing injunction where you're suggesting he may dissipate his assets. Anyway, there we are. Yes, I'm going to require you to put that on affidavit in due course.
Noted, thank you. Given that the applicant believes that the aircraft is the respondent's only valuable asset, it's submitted that there is a real risk that any judgment in favour of the applicant will not be satisfied if the aircraft is taken out of the UAE and sold. In that context, the applicant has been investigating what has been going on with the aircraft. It is established that the aircraft was deregistered from the General Civil Aviation Authority registry on the 29th of November, and it's believed that that is because the GCAA was not provided with information required to register the change of ownership.
The GCAA is a UAE body?
Yes, that's right.
Thank you. And instead it's now registered with the FAA in the States?
That's correct. And that change has been brought about by, we believe, the respondent re-registering the aircraft with the Federal Aviation Administration of the US. And
so if you look at your paragraph 14 of the affidavit, you'll see there's reference there to the aircraft being sold by the applicant to the respondent. And as I indicated, that's inconsistent with what appears in the in paragraph 2.1 of the
yes,
statement of claim. I think at all events it needs to be clarified as to who was owner and so on and so forth. I mean, your claim doesn't depend on ownership. Your claim on previous ownership. Your claim depends on the management agreement. So it's an irrelevance from that point of view, but it must be set out accurately.
Yes, absolutely. Those facts will be checked before the particulars are filed. As I've mentioned, the transaction that took place on the 28th of December has been recently discovered by the applicant.
Yeah.
We understand that the re-registration of the aircraft is the first necessary step required to prepare the aircraft to be airworthy and physically leave the UAE. And other steps have been taken that have come to light that I'll mention in a minute. But before I do that, we just want to, as mentioned in paragraph 18, give full disclosure to the court about steps that the applicant has been taking to protect its interest. And one of those steps has been to register a lien over the aircraft with the International Registry.
Now, what does the International Registry mean? Which body is that, and where is that incorporated?
I believe it's incorporated in the UAE, but I'm going to need to check that with my aviation colleague.
I'd assume that's what I'd like to know.
I'm informed it may be incorporated in Ireland, but I will confirm that and
right.
check that position first.
Being called international, it is truly international, is it then?
Well, I suspect so. Yes.
It's a place that you can register liens worldwide, so to speak, that is open to people in all countries to have a look at.
Yes.
Yeah. Okay.
And there's the entitlement to register the lien under UAE law, the Civil Transactions Law.
Yeah.
But given that the lien is registered pursuant to the Cape Town Convention, when ratifying that convention, the UAE did make a number of declarations, one of which indicated that where creditors are exercising such remedies, they can only be enforced with the permission of the onshore UAE court. And that means getting a court order onshore, and it's unclear whether permission will be granted, and inevitably it's going to take quite some time to get such an order, and it can be subject to appeal, which is why the applicant has decided to seek a freezing order in the DIFC courts.
Yes.
And there is real urgency to this application. As we've pointed out, there's a risk of dissipation, but as at the 13th of January this year, ExecuJet we're informed that ExecuJet were fixing decal stickers to the aircraft showing new US FFA registration marks. And this, I believe, is the first step following registration required to make the aircraft airworthy. Further steps will have to be taken, such as the aircraft needing to have emergency location transmitters and life raft installed before the aircraft can leave. But it's believed by the applicant that the respondent is taking active steps to try and move the aircraft out of the jurisdiction. The application has been made without notice to the respondent because it believes that once the respondent has notice of the legal action the applicant is proposing to take, that the removal or the efforts to remove the aircraft will be increased. And I think the particulars of claim establish that there is a pattern of default. And we can elaborate on that as necessary in the draft before filing. But there is a pattern of default by the respondent, and the debt has been outstanding for some time. And despite several attempts to require the require the respondent to pay, they have failed to do so. Given the risk of dissipation and the prospect that the application will be unable to recover the debt if the aircraft is allowed to leave the UAE, it is considered that the balance of convenience must lie in granting the freezing injunction. And I haven't gone into lengthy detail about English procedure and case law. We haven't had time, I'm afraid, to do a skeleton argument. The registrar did say that that could be dispensed with, but we have set out the critical elements of under English procedure for seeking an order of this nature in the affidavit.
And do you have a draft order?
We do have a draft order that should have been submitted online with the application notice, and
Right. Let me just check. It may be with the application notice then.
Can you send the exhibit to the DIFC? Because it didn't appear to be uploaded on the system.
Sorry, bear with me. I'm just looking at the draft order. Now, does this follow the standard form?
yes, that follows the standard form.
And what doesn't follow the standard form in it, if anything?
I think it is pretty much in line with the standard.
Okay. Penal notice is not right because the respondent is a corporate body and you can't imprison a corporate body. So the first two lines of the penal notice need to be changed. So it should read, if you, A&K Trading Limited, disobey this order, you may be held to be in contempt of court, and your directors, and may be fined or have your assets seized, and your directors may be imprisoned, fined, or have your assets seized. Self-evident, you can't imprison a corporate body, only its directors, so you need to change that. Yes. In practice, there are two different views about the form of penal notice, because in the court itself does not have power to impose imprisonment for contempt. The Attorney General has to take steps, but the end result is the same. So I generally take the view that that form of words that I've just given you is adequate. Now let's just look at the rest of it. Yes, I mean, I think the first question I need to ask is relates to return date and the like. What do you anticipate is the likely reaction once you've served this?
Well, I suspect they will try to apply to have it discharged relatively quickly.
Right. Okay. And so far as you can see, because you haven't mentioned any potential defences or anything of that kind, but as a matter of full and frank disclosure, can you see any basis for either defending the claim or defending the injunction and having it set aside?
There has been some correspondence, I believe, where the respondent has challenged some of the costs that have been incurred,
Right.
but we are instructed that the services have been properly performed and the invoices raised, and that the debt is properly due. Now, it may be that when we're dealing with the substantive claim, there's a dispute about what the debt is, but I would submit that it's difficult to believe that it's going to cross out a significant part of the debt on the basis of what I've been instructed about the invoices.
Right, so there's a potential defence on quantum, but not as to liability in general, is what you're saying.
I believe that's correct, sir.
Right, and so far as the injunction is concerned, what basis might there be for setting it aside, apart from him saying, I have no intention to defeat creditors, and there's no real risk of dissipation of assets? Is there any
I suspect that would be the main basis for trying to seek to have it discharged, in which case we would expect the respondent to provide some security in those circumstances.
All right. Well, in which case we should be looking at a return date, and the question is when that should be. When are you looking for a return date?
So we would, so I'm just checking the dates.
Today is Friday. Next week would be, from my point of view, difficult, but any other judge could deal with it. In the ordinary way, one would expect it 7 days, 14 days, something of that kind.
Would it be sensible to list it on the day the following week when you're available?
Potentially, yes, but in a sense, that's less important than, as I say, it's not as if a new judge is going to have to read into enormous volumes of evidence. But it, you could either be looking at, you're going to have to serve this pretty immediately in any event.
Yes.
In order to have any impact. Just looking at my diary. If you wanted to make it the subject to the court's ability to cope, the 24th of January would be just over a week's time, so that might be quite a sensible day.
Okay. Is there any particular time?
Well, it'll be in the ordinary way. We'd make that 1 o'clock, because that'd be 9 a.m. English time. That's subject to anything Charlotte has to say as to the court's ability to list it for that time.
Your Honor, if it's listed before you, then I can list it immediately and right away. Otherwise, I will have to see if we have a judge available.
All right. Well, if you can list it straight away for 1 a.m. on Monday the 24th.
Yes, so 9 a.m. London, 1 p.m. Dubai time.
Correct. Yes, thank you. All right. Okay, and so what's the figure going to be for the freezing order in paragraph 4.1?
I'd submit that it should be the current amount of the debt.
Well, don't you want to include something for interest and costs?
I believe that, well, the figure that has been put forward includes some interest, but interest will, of course, continue to accrue. And as I mentioned, there are further costs that will be falling due within a few days. Just checking the particulars of claim to see.
Well, as I read the particulars of claim, which need correcting because you better get it absolutely right. It's 1,272,798.55 as opposed to the round figure of 1,272,799. But that is made up of sums without interest. If you look at paragraph 4.3 of your 4.3 of your particulars of claim, there's no interest built into that. And then you want 3% interest. And there's a reference to interest elsewhere that I've lost for the moment. And then you'd want something for costs. Now, whether or not you're entitled to have a freezing order in respect of a debt that hasn't yet fallen due is another question.
Yes, I think further, as articulated in paragraph 4.4 of the particulars of claim, an additional sum of $45,067 will fall due on the 27th of January.
Yes. Well, what do you say you're entitled to an injunction in respect of something that hasn't yet become due? It's not yet a debt.
Yes.
The chances are it won't be paid, of course, but I'm not sure that would be right.
No, I think it's safer to put in the debt that stands due as at today.
Yes, and then you can add a sum to that for interest in respect of the period up to any likely judgment, and you can add a figure for costs.
Yes. I'd
1.3 million.
1.3 sounds about right.
Yeah, well, you know, this is always capable of being adjusted on the return date when you've been applied your mind to it a little further.
Yep.
All right. So in particular, the aircraft, yeah. Yes, and our provision of information. Paragraph 8.
Yes.
Immediately. I think it ought to be within 24 hours of service. Yes. Or notification rather than service, within 24 hours notification. How are you going to serve this, by the way?
We will serve it by courier, email, and fax.
And will that be effective service in Jebel Ali, in the free zone?
I believe so. There is a notice provision in the agreement which talks about notices.
Yes, but does it talk about service of proceedings?
No, I don't believe it does. I'm just going
to won't be adequate for that.
Exactly, but we will serve it on the entity, or I think it's the parent entity in Egypt that's named, but we will serve it on the relevant.
Do that, but for the purpose of technicality, you need to serve it on A&K Trading Limited in Jebel Ali Free Zone in accordance with the law of Jebel Ali Free Zone as well as the law of DIFC. They're likely to be the same, I suspect, because it's a free zone, but I don't know that.
Yes.
We'll come to the undertakings you're going to have to give in a moment. But there are maybe two distinct phases. One is simply notification of the injunction, which is sufficient to put the defendant on notice so that it's binding, but also service. And I'm going to suggest that paragraph 1 should be within 24 hours. It's a weekend, you better say within 48 hours of notification of this injunction. And then paragraph 9, that's going to be 3 days, working days after service, the affidavit. That seems to be sensible enough. Right, and paragraph 10.4 will be the same sum of 1.3 million. Costs reserved, variation. Yeah. Right, okay, now we're coming to, I'm looking at the affidavits and undertakings. I'm going to require you to swear a further affidavit, which records what you've said to me on instructions.
So do you require me to swear that affidavit or the colleague who's received the instructions?
Well, my recollection is, and I know this was originally a case of urgency, but essentially affidavits and witness statements should be sworn by the person at the claimant themselves rather than by the lawyers who can only say things on instructions. So I think there should be an affidavit from a senior management person at Gulf Wings FZE in which they endorse what's been said by Mr. Forgive me, I've forgotten his name.
Tebbit.
Mr. Tebbit, and also covers the additional information that you've given me on instructions in relation to the defences and in relation to the risk of dissipation. You've got a note of what you've said to me, I'm sure, because you must have had a speaking note.
Yes.
All right. Now, undertaking in damages, what sort of damages could arise here?
Well, I'm not aware of the respondent's plans for the aircraft,
No.
and if they may be looking to use the aircraft or sell it further, I don't know. But
from the look of the owner trust agreement and the lease back, it would only be probably hiring it out for use, wouldn't it, or personal use?
Yes.
The question that arises, though, is whether any undertaking in damages should be fortified in some way. I don't know anything about the claimants and whether they're an entity of substance or not.
Yes, I can't give you any specific details. We've acted for the applicant for some time on various different matters, and I can't give you very specific details about their financial worth.
Right. Well, I think that's something that needs to be covered in the affidavit. Otherwise, I would. I mean, I can't see that there's likely to be much real damage suffered before the return date. But I think the affidavit should set out the substance, the financial status, if you like, of the claimant, and say why it would be able to meet any claim in damages should it subsequently be held that this injunction ought not to be given.
Yes,
Okay.
that would be addressed.
Now, apart from the numbering, because you have 1, 3, and 5 in your undertakings, which suggests that something has been left out. But so far as 3 is concerned, the claim form, I think, needs to say to be amended. So if we say issue and serve a claim form substantially in the form of the draft produced to the court, and that will enable you to amend it to get all the details right.
Mm-hmm.
And then I think it's not just service. At 5, I would want an undertaking applicant will notify the respondent and set out the means by which you're going to do that by email, fax to the defendant and to its parent company. As I understand, you say there is one. And then serve as soon as possible. Yeah, and all the material there. What do you know what's missing offhand in paragraphs 2 and 4 from the? I assume it's from
I think
the
there may have
standard
been reference to a bank guarantee.
Yeah, it's fortifying the undertaking. That's what I thought.
Yes.
In 2,
Yes.
and what would 4 have been?
I'm
I don't
not sure.
have it in front of me. Well, let's come back to that. And what about paragraph 10? The plane is in the IFC, so it isn't a problem, is it? At
The
present.
plane is onshore.
Yeah.
Dubai.
Yes, Dubai. Yes, but
Yes.
that's okay because there's mutuality, so to speak, with letters of execution and so on. But yeah, all right. Well, I think that just about covers the ground. You will need to produce a draft of that to the registrar for the registrar's approval. You will need to look and say what's missing, so to speak, from the
Yes.
standard form, and you may need to justify that to the registrar, who will refer the matter to me if necessary.
Yes.
Could
Could I just check the timing of the affidavit? I missed
well,
that.
as soon as possible,
As soon as possible.
as soon as practicable. I mean, I'm prepared to give you the order on the basis of those undertakings that you will produce such an affidavit as soon as practicable, which confirms the matters that you've said on instructions to the court.
Yes, noted. Thank you.
All right. Now, is there anything else we need to deal with for the moment?
I don't think so, sir. We will amend the order and submit it to the registrar as you directed, and also amend.
And the amended particulars of claim.
Yes.
And have we've got an undertaking that you're going to issue proceedings, have we? Yes, issuing the
Yes.
claim form. Yeah.
Yes.
Okay. Yeah.
We've just amended it to say substantially in the form.
Yes, indeed,
draft.
yes.
Yeah.
Indeed. Is there anything else you need to take any instructions from anybody else? I see you've got Mr. Whitfield with you. I'm not sure who Mr. Whitfield is, but
Mr. Whitfield is a associate at the firm.
Right.
I don't
But
believe so.
you've got
I've been in communication.
You've got all the instructions you need.
Yes, I believe so. And we will address the matters that you've requested as soon as possible. So.
All right. Are you in Dubai yourself?
I am, yes.
Yes. So yes. I was just. You're aware of what the timescale is as to when the court closes. That's all.
Yes.
You know,
Yes.
for me, I'm still in the middle of my morning here in England, but you're in the middle of your afternoon. So.
Yes.
And being a Friday, no doubt the court wants to close.
An unusual working. Well, I think it's the second Friday.
The new usual working week, quite.
Yes, we're not liking it very much, I'm afraid.
You're not.
It makes the week feel longer, I think.
Well, that's.
But there you go.
Well, there was at least when I first read my newspapers over here, it looked as though people were going to have a 2.5-day weekend, or perhaps even a 3-day weekend. But
yes,
I'm sure,
I think a lot
it will settle to the usual 2-day weekend. It's just you'll have changed the days.
Yeah, I think lots of people were rather excited when they read the news.
Yes. All right. Well, thank you very much.
Thank you very much, sir.
You better liaise, as I say, with the registrar, and she's very good and will get in touch with me as required. As I say, I'm readily available on email, though I have 1 or 2 other engagements today.
Okay.
All right. Well, thank you very much
sir.
indeed.
Thank you. Thank you. Bye-bye.
Bye.
Bye. Bye.